This is an interesting question. It has to do with filing a state complaint and then having the school board attorney, because you don't have an attorney yourself yet, um, reaching out directly to you in order to ask for mediation. So it's a very good question for those of you that are like, well, what happens here if this happens and this is legal. So let's talk about this, okay? And the pros and the cons behind it. So let's read the question. I filed a state complaint last week. My state complaint was accepted yesterday, and you received an email from the school district lawyer asking if you would be willing to go through mediation. This lawyer has used tactics such as showing up to your IEP meeting with you only receiving the notice of the meeting the night before that indicated that legal counsel was going to be invited. That's not uncommon. It's a crappy tactic. They shouldn't do that, but it's not. It's not prohibited. Okay, so crappy, they shouldn't do that. I think it says a lot about the lack of transparency in administration more than it does anything else. But let's continue. This attorney has also restricted your communication to only the special education coordinator herself and the school principal. You've read and heard that mediation works to the parent's advantage with due process, but not for the parent in regards to state complaints. What do you recommend in this situation? I find it odd too that the school district lawyer contacted you directly. Should I respond to her email, or would it be better to communicate through the SCO? And I'm imagining the state complaint office. It's not uncommon. If you're not represented, the school district attorney can reach out to you directly. Okay, I don't find anything odd about that. And I don't think they shouldn't go through the state complaint office. And I know you're in New Jersey, but that's in the other states. That isn't how the state complaint office operates. They have your complaint in hand, and then at that point, what they do is they send it over to the school system, which of course would go to their attorney. And the school has an option. They can either just respond to your state complaint and leave you alone, or they can reach out to you and say, hey, we understand that you have issues. Let's try to resolve them and make an offering of mediation. So that's not inappropriate. Also, it's not uncommon in order to sort of streamline the dispute to ask that the communications be directed through the administrators. Now, why is that? Because the soldiers on the ground that are in charge of educating your child, they don't need to be involved in the drama of the dispute of what is or isn't working on the IEP. You have an IEP team meeting for that, but any kind of other communications, I do that in our practice. I don't recommend. In fact, I don't even like resolution meetings, and we file complaints all the time. Now, why don't I like resolution meetings? They have to happen. They have to happen within the first 15 days after I file. But at the same time, I don't find them beneficial meetings, because my problem in how we and the parent get to a finality and a solution is through administration. And so if I include the entire IEP team, I'm including people that are also victims of this process. They weren't given the right training. They weren't given the sufficient resources. There isn't enough support. So I don't blame the teachers for what tools they don't have. And so having them in these meetings as spectators with popcorn, or feeling themselves like they're under attack, I find negative, and I don't find beneficial to our end goal, and that is having these problems addressed through administration. And then once we have a finality and an understanding of what needs to be corrected, then bring the IEP team in and let's kumbaya, buy the world of Coke, join hands, sing hallelujah, and fix the problem. I just have never seen the benefit of having staff there because it unnecessarily inflames the process. But then also the strategy is as well that guys, when you sit there and you have administrators in a meeting where you're attacking them and you're attacking the district, it is a natural reaction from anybody with any kind of an authority. I don't care if it's a parent, I don't care if it's a minister, I don't care if it's a cop, anybody with or an administrator like a principal or a special ed director. you put them in a position to where the people they're responsible for, whether it's their children or their teachers or whatever else, and they're getting lambasted, then the natural reaction is to defend your people, even if what you're saying is correct. It is the natural inclination to defend your staff, remove the staff, so that they don't have to be put in the position to feel like they have to defend their staff, regardless of how right you are. Okay? It is just a strategy for success. Believe me, I teach this kind of stuff in Advocates University, guys. These are the simple strategies that I'm telling you. It helps eliminate and alleviate these problems so you can get to the core of what the issues are and get them resolved. So in this particular situation, I don't see any harm in mediation. You still have your state complaint open. So you go to mediation, and if there's no correct, if it doesn't work out, your state complaint's still out there. Okay? It is only if you reach the terms of the agreement that there would be a provision stuck into your mediation saying that that you agree to withdraw your state complaint. Okay, but that's only if you reach terms and you sign and you agree. Now, the one thing that I would respond back is if you agree to mediation, will they agree to, if you would obtain an attorney to help advise you, if they would agree to mediation if you retain an attorney? Because at that point, it would put you in a position to have your attorney fees reimbursed or paid if you have an attorney participate in that mediation. But I would ask that attorney first. But if you feel confident in negotiating this yourself, if you understand what it is that you're requesting with regards to corrective action, then by God, there's no harm in you doing that. All your rights are still there. If the meeting breaks down and you guys leave, you still got your state complaint open. So no harm, no foul. All right, but I don't know what it is specifically you're saying that they did wrong. I'm not a big fan of state complaints unless you are pointing out procedural violations. That they're not following the rules. Okay, but if you filed a state complaint for anything related to substantive harm, to where your child's regressing, your child's stagnated, and your child has not received a free, appropriate public education because the IEP that's been developed was not developed to be reasonably calculated to provide your child with that free, appropriate public education, and as a result, your child has regressed or stagnated. See, that's the substance of your child's IEP. That's what we call substantive harm in the law. That's what hearing officers analyze, not something that state complaint offices do or do well, okay? But because each state has a responsibility under IDEA to be the compliance office, meaning that they go into the individual schools periodically and they do an audit to ensure that they're following and they're compliant with the rules. And then, of course, the state has to provide that to the federal government. And, that OSEP oversees that, okay? So it sort of depends on how you're using the state complaint system. If it's for substantive issues, I would go to mediation and I would try to get it resolved. If it was about procedural, you have a pretty good run with the state complaint system. But I would still go to mediation and get the thing resolved, or try to. But substantive, if you are complaining about substantive issues where it resulted in harm, educational harm to your child, the risk with the state complaint is if it comes back that the state complaint office didn't agree with you, you still retain your right to a due process complaint. It just hurts you because it makes it appear as though some agency made a determination of whether or not your child received a FAPE. And I wouldn't, it's like asking, if you've seen the movie Alien, it's like asking, Mama Alien to sit in judgment of baby aliens, okay? It's the education system make any determination of whether or not FAPE was provided by another education agency. I didn't find that they're not neutral. Whereas our hearing officer system is supposed to be set up as independent and detached hearing officers that are neutral. Okay, that's the big difference. But I don't see any harm in it. And no, they shouldn't be doing these little tactics I talked about. And that's something that you can request in your mediation, is that they agree to give you sufficient notice in advance of inviting their attorney so that you have an opportunity to obtain one yourself if you so choose. You can put that into your agreement. And I recommend you do.